So I'd like to welcome everybody on the call to the latest instalment of the Forbes Insurance Training webinars. For those of you that don't know me, my name is Claire Opachik and I'm a partner in our Manchester office. I specialise in dealing with employers' liability and public liability claims. Before we get started on the session itself, I'd just like to touch on a couple of housekeeping points if I could. Firstly, just to confirm, today's session is being recorded. A copy of that recording and a copy of the slides will be made available to any participants from the session. So if there's anything you miss, anything you want to go back and revisit, you will have a copy and are able to do so. Secondly, after the session concludes today, there will be a short questionnaire that pops up just about your thoughts on the programme and the session and what we're doing. If you could stay on the line just to quickly complete that, it will be much appreciated just to ensure that we can tailor any future sessions to people's requirements. Like I say, it just takes a second or two to pop up once we finish the webinar. Thank you. So we're here to talk about vicarious liability. So what are we going to cover today? Well, we're going to be covering what is vicarious liability, and we're going to be looking at when it arises. This session is aimed at providing you with an overview in respect to that topic and a reminder of where the law has got us to date, highlighting the key factors you need to be aware of when assessing the risks for your own claims. We'll be featuring relevant case law to deal with this subject and using that to illustrate the way that the court approaches this doctrine. Obviously, we can't cover everything in this session, but we'll hopefully pick up on the key points for you to enable you to feel you've got a good grasp of what you need to be looking at. I will be happy to answer any questions that you might have in respect of the subject. So feel free to add any questions to the chat function. Plan is to address them at the end of the session. But yeah, feel free to let me know if you've got any issues that you want to explore further. So, what is vicarious liability? Well, vicarious liability is a common law principle, so it's not set out in any legislation. Because of that, it has allowed it to become an area of law that is a little bit flexible, has maybe been adapted over time. It's a strict form of no-fault liability, and I say that because obviously it's applying a liability to someone who hadn't actually done the wrongdoing. You're holding a employer liable for the actions of someone else, i.e. usually their employee. And so it is a strict liability finding. It will only apply in a employer or quasi-employer type scenario because it's arisen out of the old concept of the master-servant relationship, where a master would be liable for all of the actions of his servant. Whilst the world has moved on and we've moved away from that kind of overarching control that the old-fashioned master-servant dynamic might have had in the years gone by, the principles have simply been transferred across to the more standard employer-employee relationship that we're familiar with. And it basically ensures that injured parties can receive compensation for wrongs that are made against them by realistically transferring the liability to a party that's got probably a greater means of paying them. The important thing to obviously remember is that this is secondary liability, so it will only arise if there was an actual primary liability. As a result, you have to consider at the start of any case that involves this, whether or not there was an actual breach of duty by the wrongdoer themselves, whether there was a tort, breach of contract, whatever, that was committed by them that's then passed on to the employer. We won't be obviously going into that today, but yeah, just bear it in mind. So, how do you establish vicarious liability? You do so via a two-stage test. The first point is whether the relationship between the defendant and the tortfeasor is one of employment or akin to employment. And the second is whether the wrongful conduct was so closely connected with acts that the tortfeasor was authorised to do that it can be fairly and properly regarded as being done whilst acting in the course of their employment. There has been significant case law discussing how to assess both stages of this test. And so we'll be looking at a number to get a sense of the factors that have been looked at by the court and also the way in which they're applying both arms of these tests. Because there's voluminous case law in respect to this, we won't be going into all of it, but I'll be including on the slides probably more cases than we're going to talk about, so that you have got the reference details there if you want to go back in your own time and look into anything in any greater depth. I will flag at this stage that unfortunately quite a lot of the case law around the issue of vicarious liability can deal with some dark subjects. There'll be quite a few cases that we talk about today that are dealing with some form of abuse. I won't be going into the great detail in respect of any of that if anyone's concerned about that. But we will obviously be discussing an overview of the wrongdoing that is considered in the case law. I'll be going through each of the tests in turn to address the way that the court assesses those, and hopefully then that will enable you to make your own decisions in future as to whether this applies to your matters. So let's look at stage 1 of this test. Is it employment or akin to employment? For a great number of cases, you won't need to spend a heck of a long time thinking about this. It will be clear cut, it will be very obvious somebody is employed, they're being paid, they're doing their 9 to 5, they're turning up at the hours, they're wearing the uniform provided, and it will be very straightforward to assess this. But there are a number of roles which might not fit as closely within that kind of standard employment relationship. And so the courts have spent some time going through different scenarios in respect of how you should apply this test to make a decision in respect of whether or not someone is employed for the purposes of this. I know obviously there are other areas of law where we might consider the issues of whether someone's an employee and they haven't taken those tests in the exact same wording, and they've applied slightly different reasons in terms of making a decision on this point. The court in the Catholic Child Welfare Society case that's listed at the top initially identified 5 policy reasons that they would consider made it fair, just and reasonable to impose vicarious liability. And those 5 reasons were: 1, the employer is more likely to have a means to compensate; 2, the tort was committed as a result of the employee acting on behalf of the employer; 3, the employee's activity was likely to be a part of the employer's business activity; 4, in employing the employee to carry out the activity, the employer created the risk of the tort that was committed; and 5, the employee will have been to some degree under the employer's control. The court did, however, concede that not all of those factors are equally significant and different weight would be applied to them. The language used by the courts has then evolved as the cases have moved on, and so that test has kind of been adapted by the judges that followed. So if we take the E, an English province claim, just to give some background to this matter, the case concerned a claimant who alleged that she had been sexually assaulted by a priest while she was a resident of a children's home within the parish of the said priest. The court were asked to consider if the diocese trustees, and i.e. on behalf of the bishop, were liable for his actions akin to the way that an employer should be. And in that case, the court adapted what had gone before and focused on 4 factors that they identified. And those 4 factors were the control test, i.e. the extent of control the organisation had over the individual. So in this scenario, a priest had quite a significant level of autonomy in terms of what he did on his day-to-day duties. He wasn't directly supervised or overseen by somebody. But at the same time, there was a level of control that was exercised over him. He couldn't get away with not having masses in his church. He couldn't get away with not following the rules of the church. So there was some level of oversight, even if it wasn't on site physically within his parish, and it wasn't necessarily every day. The second test was the organisation test. Was the individual's activity central to the function of the organisation? And here, with the priest, obviously he's representing the church, he's representing them at a local level, and he needs to be carrying out the church services and the functions of the church on behalf of the wider diocese. So he kind of was central to their organisation and what they did and the offering that they made to the community. The third test was the integration test, whether the individual was integrated into that organisation. I think the court referred to the priest and his parish as being like the local branch of a shop, a bank, a business. It was an arm of that organisation. It might stand separate, it might have its own structures, but it was representing that business, and so it was integrated within the organisation. And the final test they used was the entrepreneur test. Was the individual more like an independent contractor than an employee? And in respect of that, there were factors here that fell on both sides. A priest is not paid a wage, so there was not that usual kind of transactional relationship that you might see with an employer-employee. A priest takes his living expenses out of the collections and things that the parish raises. However, unlike an independent contractor, who you would think was in business for themselves and trying to raise profit, a priest could not keep the rest of the collection that maybe went above his living expenses and use that as profit for himself. He had to invest that into parish funds. So he wasn't acting as such like an independent contractor might be expected to. Based on that, the court were happy to accept that a priest did function in a quasi-employment role. And as a result, this first test was met. If we move on quite a few years from that decision, the guidance has been refined again in the trustees of trustees of Barry Congregation of Jehovah's Witnesses versus BXB. And this is primarily the leading judgment in respect of this test right now. The case concerned an elder within the Jehovah's Witnesses who raped a fellow member of the Jehovah's Witnesses. And the court had to consider, obviously, whether or not he was an employee, and then obviously the second stage, if that was met. When the Supreme Court looked at this, they actually considered that the lower courts had erred when assessing this test by considering factors within the criteria for the first stage one test that were in fact more part of underlying policy justifications for vicarious liability. And so in the judgment, they advocated for the following factors to be the deciding points in terms of whether or not this test was met. And the factors they set out were whether the work was paid for by money or in kind, how integral to the organisation is the work carried out by the tortfeasor. Number 3, the extent of the defendant's control over the tortfeasor in carrying out the work. 4, whether the work is being carried out for the defendant's benefit or in furtherance of the aims of that organisation. 5, what's the situation with appointment and termination? Can you fire someone? Are you in control of hiring them? And 6, whether there was a hierarchy of seniority into which the person's role would fit. You can see there's quite a lot of similarities in the wording of those tests to some of the earlier case law that we were talking about, but we've refined the language slightly, and we're separating points out in a more structured format. The court also confirmed that once you'd applied those criteria, you also then needed to stand back and check against the conclusion whether the imposition of vicarious liability was fair, just, and reasonable in all the circumstances. They confirmed where it's clear that a primary wrongdoer is carrying out their own independent business, vicarious liability will not arise. So looking at that case in particular, the court accepted that an elder in the Jehovah's Witness church was akin to employment. It is an unpaid role, as that was a factor against that being found. However, each individual factor by themselves is not determinative. You have to look at the wider picture, balancing all of the 6 factors. And here, he carried out work on behalf of and assigned to him by the Jehovah's Witnesses. He sought to further the aims and objectives of the Jehovah's Witnesses. Elders in their community are appointed and removed by the group, and there is a clear structure and hierarchy in place into which he fit. And so on balance, the court was happy that actually he was in a relationship akin to employment. To look at a couple of other scenarios and see how this works, I'm going to mention the case of Cox. That's obviously on the slide as well, Cox versus Ministry of Justice. In that case, a prisoner working in the kitchen of a prison made a spillage, which the claimant fell on. And the question was, is the MOJ vicariously liable for the actions of the prisoner? The MOJ tried to resist liability in this regard by saying that actually, under rehabilitation policies issued by the government, they were obliged to make him do work whilst he was serving his sentence. And so it wasn't akin to employment. The court, however, rejected that. Whilst he was required to undertake work under rehabilitation policies, the prison benefited from that work. If they hadn't got him doing the cooking in the kitchen, they would have needed someone else to make meals for the prisons. And so that work would still need to have been covered. He might not have been paid the full wages you would have paid a civilian to do the task, but he did in fact get paid for his efforts. And so on balance, the court was happy to accept that a prisoner working in this kind of environment was akin to an employee, and mentioned that they thought it would be unfair to a victim if she could have claimed when the spillage was created by a civilian worker in the kitchen, but not by a prisoner. Differently, however, in XVW, that case involved a secondary school that took a number of pupils on a trip to work in Belize. The group of secondary school students stayed on a farm run by a local man, and I understand undertook work to cover their bed and board whilst they were there. The local man's son acted as a bit of a guide for them, and he would also demonstrate the tasks that they were supposed to be carrying out and show them what they were supposed to be doing. During the trip, however, he unfortunately attacked and raped several of the pupils. And when they returned to England, the pupils attempted to sue the school on the basis that they were vicariously liable for the actions of this man. They didn't succeed, and the court accepted that the relationship was not akin to that of an employer-employee. He was not a supervisor of the children. He was not asked to be a leader of the group. He was present on the site due to his relationship with the landowner, not because the school had sought for him to be involved. And as a result, there was that distance between the school and his actions. I've included a more recent case on the slides of MXX. That involved a work experience placement person at a school who groomed a pupil. Whilst the school might not have ultimately been found liable for his actions, the court did accept that he was found to be in a relationship akin to employment, and so it passed stage 1 of this test. And the reasons that they found that was that he was required to adhere to the safeguarding policies like everybody else. He was supervised by other staff at the school in his tasks. He was assigned things to do, and pupils were required to treat him as if he was a member of staff. And so on that basis, he was found to be an employee type relationship. So you can see from the cases we've talked about so far that already there's quite a wide range of opinions in relation to what constitutes employment. but actually there's kind of a common theme flowing through them. I'm going to focus on a couple of last key cases here because I think they're probably the most crucial ones. Like I say, there are other cases listed there if you want to read into them in your own time. So the penultimate case I'm going to talk about in respect of this issue is the Barclays Bank case. And I think this is a really useful one to highlight the approach in respect of this, because it is a decision that was overturned and went a couple of different ways on its journey to the Supreme Court. For background, for those of you that aren't familiar with it, Dr. Bates was a self-employed medical practitioner. His work included conducting medical assessments, and one of his roles was examination of prospective Barclays employees as kind of a pre-job medical examination. So Barclays would require applicants to pass the medical examination as part of their recruitment policy. Barclays arranged the appointments with Dr. Bates, and they gave him a pro forma report with questions that he needed to fill in, and it was headed Barclays Confidential Medical Report. Dr. Bates was paid a fee for each report he did, but they didn't pay him a retainer, and he conducted the medical examinations in a consulting room at his own home. It was alleged that Dr. Bates, in the course of carrying out these duties, sexually assaulted 126 claimants. He died in 2009, and as a result, the claimants in question sought to claim damages from Barclays on the basis they were vicariously liable for his actions. At first instance, the court agreed. And in fact, the Court of Appeal agreed that Barclays should be vicariously liable for his actions. Barclays appealed to the Supreme Court, who unanimously allowed their appeal and held that they were not vicariously liable. And that judgment given confirms that it is clear a person can be held vicariously liable for the actions of someone who isn't their employee, provided that the relationship between them is sufficiently akin or analogous to employment. However, there is a classic distinction between employment and an independent contractor. And here, the balance meant that Dr. Bates was an independent contractor. At no point was he an actual employee of the company. He worked in a business on his own account as a medical practitioner and had a portfolio of patients and clients that were not Barclays. He did work for Barclays, and they made the arrangements for the examinations, and they did give him questions that they wanted him to answer. But that level of direction is akin to the kinds of instructions you would give to a number of different independent contractors, and did not necessarily indicate the level of control that you would expect to see between an employer and an employee. He wasn't paid a retainer, so he wasn't actually obliged to take their instructions at any point. He was paid a fee for each report, and so free to refuse to take it every time they went to him and asked if he would do the examination. He probably had, his own organisation and administrative aspects, and probably even his own insurance in respect of this. And so on balance, it was difficult to see how he could be considered anything other than an independent contractor. And I've got to say, I do agree with the Supreme Court in this regard. I remember when the original decision and the Court of Appeal decision came out, it felt to me influenced by sympathy for the claimants rather than being an analytical approach to the reality of the way that Dr. Bates was working. So the last case I'm going to touch on in respect of this topic is the DJ and Barnsley Metropolitan Borough Council case, which is relevant for anybody in local authority work or care situations. This is probably the most recent decision that we've had in respect to the topic, and it re-examined the foster carer scenario some years after the original relevant decision in the Arms case. In this matter, the claimant alleged that he had been assaulted by his uncle whilst he was living with his aunt and uncle, and they were acting as his foster parents. He sought to hold the local authority vicariously liable for that abuse, and this matter went to the Court of Appeal. That decision by the Court of Appeal found that the relationship between his kinship foster carers and the local authority was akin to employment. The court had regard to the factors as set out in the previous decision about BXB, and concluded that from the date the fostering assessment was completed and approved and the claimant was received into care under the Care Act, he was under the care of the local authority, and they were therefore under a statutory duty to care for him. The local authority had discharged that duty by recruiting and selecting his aunt and uncle as his foster carers. And even though they were family members, that didn't mean that they couldn't be quasi-employees. The fact that the couple would not have fostered him if he wasn't related to them was not relevant to determining the relationship. The local authority had a job that needed to be covered, i.e. foster carers, and they recruited and hired these couple to conclude that duty. And as a result, it was not ruled out just because they were related to the claimant. So, in summary, when assessing stage 1, the factors that we need to look at are, was money exchanged or something in kind for money to reward the work that was undertaken? How integral to the organisation was the work carried out by the tortfeasor? Are they part and parcel of the organisation? The extent of the defendant's control over the tortfeasor? Are they working under the supervision and direction of an employer? And it's important to bear in mind in respect of that the level of direction or supervision that might be provided in this regard will depend on the roles that we're talking about. It's been discussed in case law that you can't expect in very technical professional roles for supervision to be necessarily as direct and hands-on as it might be in a more administrative role. So, for example, like a doctor, a surgeon, you wouldn't expect the manager of that person to necessarily be telling them how to operate. They have to let them do what they're technically good at, but at the same time, you can see that they stand within the overarching control of the NHS and the managers within it. So it is important to just kind of bear that in mind, that you don't need to be necessarily standing over them, supervising them for this criteria to be met. Is the work being carried out for the defendant's benefit and the furtherance of their aims? Is there a hierarchy of seniority into which the role fits? And are they subject to managerial processes with control over their appointment and termination? So you look at all of those. They don't all need to apply, but there needs to be a balance that shows that actually overall it seems to be akin to employment. And like I say, there's this reference to stepping back, assessing your decisions. Do they appear, once you've looked and balanced the criteria, as if it's fair, just and reasonable? And if you do meet that criteria, then we need to move on to stage 2, the close connection test. Again, I've included on the slide a number of cases. I'm not going to talk about them all, we'll be here all day, but I'm going to pick out a few key cases and a few important factors I think that you need to bear in mind when looking at these cases to weigh up if you've got a situation that meets the criteria. And I think we can't talk about this subject without starting with the Lister case. That matter involved the unfortunate sexual abuse of pupils that were staying at a school boarding house, and the abuse was carried out by their warden. And in the case, it was found that the activities by the warden were closely connected to work to justify stage 2 being met. In the judgment that was given, it was mentioned that it's not necessary to ask simplistic questions whether the case is under consideration. The acts of sexual abuse were modes of doing unauthorised acts. You needed to consider the case and the question of vicarious liability on the basis that the employer undertook to care for the boys through the services of the warden, and that there was a very close connection between the torts of the warden and his employment. They were committed in the times that he was working on the premises of the employer and whilst he was caring for the children. So the sexual abuse that he committed was inextricably interwoven with the carrying out of his duties. I think the next 2 cases that are listed together on the slide of Waddell and Warbank are a useful contrast in respect of how this test applies. They were conjoined appeals that were heard together, and so, like I said, they kind of go through the factors that are needed to meet this criteria, and do provide a contrast. So just to set out the facts of both, in the Waddell case, Mr. Marsh worked at a nursing home operated by the defendant, and he had a bit of a beef with his deputy manager, the claimant. They were known to have animosity between them. He wasn't actually working on the day in question. He was at home when he received a call at about 6 p.m. from the claimant, asking if he could come in to cover a shift, because I think someone hadn't turned up. I think maybe they were ill or something like that, and he basically had an absence that needed to be covered. The claimant was drunk and so very irately refused to come in and refused to work. But after putting the phone down, he then decided to travel to the care home in question. And when he arrived, saw the claimant stood outside, and so marched over to him and punched him. In Wallbank, we have a similar but slightly different scenario. The claimant was employed at his own company, and one day saw an employee doing his job inefficiently. So he went over to kind of say, oh, no, don't do that. This is how you should be done. And said, come on, I'll give you a hand. And as he did so, the employee became incredibly irate and threw him across the room. So we've got both scenarios involving acts of violence against a colleague. So how did the court approach whether or not there was a close connection test? Well, in the Waddell case, vicarious liability did not apply, but in the Wallbank decision, vicarious liability did apply. So why have we got a different outcome? Well, the courts considered that there was actually little connection between Mr. Marsh being asked to do an extra shift and his assault. He wasn't at work when the request was made, and he refused to work. He attended not to work, and it seemed very much that the request of him coming into work was being used as a pretext for him unleashing ill feelings against the claimant, and basically venting his grudge. By contrast, in Wallbank, the tort was very apparently connected to the employment. It took place during work hours, it took place at the workplace, but it was also a spontaneous reaction to a work instruction. His employer was telling him how to do his job and what to do next. And whilst he reacted in an irrational manner that might not have been predicted, it was part of the work activity. Whereas by contrast, Mr. Marsh coming into the care home seemed to be far more motivated by a long-term animosity. And when you look at it in that regard, you can kind of see what you need to establish in terms of the close connection test. Following on from that decision, we also had the Sainsbury's case that occurred in 2013, and a similar outcome applied in that one. In that matter, a racist employee who was employed kind of a shelf stacker kind of role took a kitchen knife off the homeware section in the store and stabbed an Eastern European colleague to death whilst at work. The deceased had previously complained about the killer and his language a couple of days earlier, but Sainsbury's hadn't done anything about it. And as a result, the family of the deceased attempted to suggest that Sainsbury's should be vicariously liable for the actions of his killer. In fact, Sainsbury's were not found vicariously liable, and the court took the view that there needed to be a strong connection between what the employer was asking the employee to do and the wrongful act. The employer must have increased the risk of harm by requiring the employee to carry out the task. And the court was not prepared to find that employing people to stack shelves significantly increased their risk of them becoming victims of a fatal assault. And it felt very much that they thought the perpetrator in that case was motivated by grudges and animosity that didn't have a connection to work, similar to the early Barchester healthcare case. I would, however, just flag in respect of this matter, it's a useful kind of case to know about in terms of how the court will approach these things, but in terms of using it as a precedent, this is a Scottish decision, and whilst it was heard by the Inner House on appeal, it was actually only a strikeout application. It wasn't a full trial, and so there would have been less evidence available to the court and less arguments in respect of these points. So that is just worth bearing in mind if you do want to look at this case in more detail. I'm just going to pick out the two Morrison's cases to talk about next. I'll be honest, for a while it felt like all vicarious liability decisions were going to involve Morrison's. They didn't have a good run. But again, I think these two cases highlight the contrast and how this test is applied. So if we talk about the first one, the claimant visited the defendant's petrol station and he entered the kiosk and asked the member of staff behind the counter if he could print some documents on a USB stick. Mr. Khan, the employee in question, refused the request and used quite racist and threatening language towards the claimant and told him in no certain terms to leave the site. The claimant returned to his car, but before he could drive off, Mr. Khan followed him outside and opened the passenger door and punched him. The claimant gets out the car and I think tries to shut the door of the car so he can drive off, but he's in fact then assaulted again by the employee. The claimant brought proceedings against the supermarket on the basis they should be vicariously liable for the actions of their employee. And the claimant was unsuccessful up to the Court of Appeal stage because the court sort of initially felt there was not sufficient close connection between what he did and what he was employed to do. That was, however, overturned on appeal, and the Supreme Court concluded that at no point during the actions that we're talking about did Mr. Khan metaphorically take off his uniform. And in that regard, I think they were basically getting at the fact that it wasn't a personal quarrel. It wasn't a grudge that existed outside of work. Mr. Khan was asked to do something by a customer. He took offence at the request that was made and as a result started to get aggressive as a result of that request. Throughout the entire interaction with the claimant, he continued, however, to hold himself out as representing the defendants because he kept ordering the claimant off the premises, implying that he had control, implying that he was acting on behalf of the owner of the premises. And so because of that, it was in fact tied in with his employment. And whilst Morrison's would not have ordered him to do this, were not aware that he was doing this, they were still vicariously liable for his actions because it was part of his work when he did them. The second case that was made against Morrison's, which is the various claimant one, slightly different scenario. We have a disgruntled auditor working for the supermarket. I think he's disgruntled because he'd been disciplined. Decides he's got a grudge against the supermarket, so he takes the payroll data of the defendant's staff and puts it on a USB stick and then takes it home where he uploads the data to the internet, creating a massive data breach. The claimants tried to hold Morrison's liable for that, but they were unsuccessful. And they were unsuccessful because there was not sufficient evidence of a close connection with work to find vicarious liability. The rationale for this was because the wrongful act that was committed was not done whilst engaging in furthering the employer's business, but instead was a deliberate attempt to harm the employer as part of a vendetta against them. So it couldn't be seen to be tied to work because he wasn't actually doing work at the time that he did it. It had nothing to do with his job, so liability shouldn't apply. Hopefully you'll see the kind of pattern that's emerging here in terms of how this is being applied. Just finally on this subject, to go back to the trustees of Barry congregation case, obviously we talked earlier about how the elder was found to be akin to an employee, but that case actually failed on the basis of the stage 2 test, and the claimant could not meet this close connection test. And the reasons for that were that at the time of the rape, the wrongdoer wasn't actually carrying out his duties as an elder. He was at his house. He'd been having some kind of emotional issues around the time, and the claimant had gone to his house as a friend to offer him emotional support. He hadn't been grooming her through work. He hadn't been utilising his control as a position of an elder over her when the rape took place. He basically was abusing her in the position of a friend and not as an employer-employee situation. So, in summary, where does that leave us? So you need to think about whether the wrongful conduct was so closely connected with acts that the tortfeasor was authorised to do that it can be fairly and properly regarded as being done by the tortfeasor whilst acting in the course of their employment or quasi-employment. I've set out below the test just a couple of factors that the court have referred to in previous decisions as influencing that decision. And they've looked at things like if it's a mode of doing an authorised act, even though the act itself wasn't authorised, if the objectives of the employer couldn't be achieved without a serious risk of the employee committing the wrong that he did. So that's kind of looking at the Lister case where the warden had the opportunity to abuse the children because of the tasks he was asked to undertake for the employer. Whether it's closely related in work in both time and space, so thinking about the Warbank case, what functions have been entrusted to the employee by the employer, and was there a connection between that wrongdoing and the position he was employed in to make it right for the employer to be fixed with liability. And also there's been references to whether or not work equipment that might have been used in the wrongdoing was provided by the employer involved. So again, it's kind of looking at everything in the round, assessing it, and taking a decision as to whether or not it is closely connected to work. Like I say, you need to look at these factors, but do go back to that test in terms of making the final decision about whether or not stage 2 is met. So, overarching position, look at firstly, is there a breach of liability on a primary liability basis by the wrongdoer? Without that, there can't be liability. Then look at the stage 2 tests. Is there a relationship with the wrongdoer sufficiently similar to employment for it to be reasonable to impose vicarious liability? And it will not cover an independent contractor. So if you can show that this person is an independent contractor, you should be able to get out of liability at this stage. If, however, it's considered that they are going to be considered an employee, then we need to move on to, is the wrongdoing sufficiently closely connected with or incidental to what would be authorised or expected of the employee? And don't forget, then you need to also be taking this step back and thinking, is it fair and just here in this scenario to impose vicarious liability? And you'll see from the case law that we've talked about today that over time there's been numerous attempts to kind of push and stretch the remit of vicarious liability. But generally speaking, every time it stretches slightly, the courts then roll back a little bit to make sure that this is tightly controlled, so that we can't be applying vicarious liability in respect of anything and everything. So, like I say, you do need to kind of make sure that we're dealing with someone who would meet an employer-employee relationship. In this day and age, obviously, we have got strange contracts that take place. We've got, 0 hours contracts, things like that. And people might not necessarily fulfill all the boxes in terms of what you would expect from a normal employer-employee relationship, but that doesn't mean it won't apply. But if somebody is running their own business, holding their own accounts, doing work for other people, providing their own equipment, directing their tasks as they see fit, they're probably going to be an independent contractor, in which case it shouldn't apply. Hopefully this has been a useful, quick skim through the case law on vicarious liability and the things you need to weigh up. I have deliberately kind of left a bit of time for us to ask any questions that you might have in respect to this subject. And if anyone has got anything they want to put in the chat, I'm happy to address them now. Alternatively, if people don't want to do that, my details are on the screen, so people can contact me at a later date if you want me to give you any specific feedback on matters that you might have.